20 words per minute. Ready? Start para. The petitioner is supported in his submissions by the management, relying upon the dates and sequences of events recorded above. The learned advocate for the management has vehemently canvassed that the appointment of the petitioner cannot be faulted. He deserved to be granted approval and he is entitled for salary to the extent of the grants as are available. Paragraph. The learned EGP relies upon the affidavit in reply dated 20th July 2021 of the Assistant Director of Education Kolhapur and submits that initially wide government resolution dated 2nd May 2012, the government had imposed a ban on recruitment. The vacancy at issue occurred with effect from 1st November 2012. After Mr. Shivaji Vithoba Khoth superannuated on 31st October 2012, the vacancy could not have been filled in by appointing a candidate from the open category considering the backlog roster. Paragraph. In paragraph number 5 of the reply, it is asserted that as per the roster maintained and verified by the Assistant Commissioner, Konkan Region, Navi Mumbai, at the 94 teaching posts earmarked for open category were duly filled in by the management and no vacancy for open category was available. As on 1st January 2015, when the petitioner was appointed, he belongs to the open category. Paragraph. He further submits that the part-time engagement of the petitioner from 2001 is of no consequence. He had applied pursuant to the advertisement dated 6th May 2014 and had subjected him to the selection process. He was selected in view of his interview and was appointed as a full-time teacher on 1st January 2015. When the roster for the reserved categories had to be honored and the backlog should have been cleared, the appointment of the petitioner cannot be approved since he belongs to the open category. Paragraph. He further submits that merely because the petitioner was working on a part-time basis does not entitle him to appointment on full-time basis, as if his employment on part-time basis could make him entitled to the full-time post. If the management did not get any candidate from the backward category, the said post should have been re-advertised. The government resolution is that after 5 years of such advertisement, the post would then get transferred to the next reserved category. The management has unilaterally appointed the petitioner knowing well that he belonged to the open category. Paragraph. We find that the submissions of the learned EGP cannot be faulted. He is justified in contending that the reservation roster has to be honored, and if there is a backlog, the same had to be cleared by appointing candidates from the reserved categories. He further points out the management has indulged in a serious illegality by advertising several posts on 6th May 2014 when the order was passed by the Deputy Director Education on 17th June 2014 permitting only one post to be filled in. Paragraph. He submits that since the advertisement was contrary to the communication of the authority, dated 17th June 2014, the management should have withdrawn the advertisement, and after correcting the advertisement in terms of the directions of the Deputy Director of Education, a fresh advertisement should have been published. His further serious grievance is that the interviews were held by the management on 22nd December 2014, which is after 7 months and 15 days post publication of the advertisement. Full stop.